Intellectual property claims can be devastating for businesses and creators. When someone believes you've infringed on their intellectual property rights, the consequences can include costly legal battles, significant financial damages, and permanent harm to your reputation. But with proper knowledge and preparation, you can both protect your own intellectual property and avoid infringing on others. Intellectual property encompasses a wide range of creations and innovations that receive legal protection. These include trademarks, which are words, symbols, logos, or colors that distinguish products or services in the marketplace. Copyrights protect original creative works like books, music, art, films, and software code. Patents safeguard inventions or processes that are novel, useful, and non-obvious. And trade secrets cover confidential business information such as formulas, methods, or customer lists that provide a competitive advantage. Other protectable intellectual property includes product packaging, known as trade dress, jingles, slogans, and even distinctive smells and sounds that identify a brand. The key requirement is that the claimed intellectual property must be original and used in a manner that qualifies for legal protection. Many people hold misconceptions about intellectual property law that can lead to costly mistakes. One common myth is that large companies enforce their trademarks just to bully smaller businesses. In reality, these companies are exercising their legal right to protect assets they own. Furthermore, if trademark holders don't enforce their rights, they risk losing them altogether. Another misconception is that using intellectual property without profit provides automatic fair use protection. This is not necessarily true. Even without financial gain, distributing copyrighted materials or building replicas of patented inventions without permission can constitute infringement. Additionally, many assume you can only trademark what you personally invented, but trademark law specifically protects brand identity elements that help avoid consumer confusion, regardless of who created them. Intellectual property disputes take several forms. Trademark infringement occurs when a business uses a mark similar enough to a protected trademark that it could confuse consumers. Copyright infringement involves unauthorized use or reproduction of protected content. Patent infringement happens when someone uses, manufactures, or sells a patented invention without permission. Trade secret misappropriation is the unauthorized acquisition or disclosure of confidential business information. Domain name disputes arise when website addresses closely resemble existing trademarks. To avoid intellectual property claims, first acknowledge that legal exposure exists regardless of your intentions. Develop internal processes to minimize risk, such as implementing an IP compliance program and training all employees. Consider obtaining insurance protection through standalone IP policies, patent defense policies, or infringement cost reimbursement plans. Also, reduce social media exposure by creating strong policies that limit employee use of social platforms on company time or technologies. Protecting your own intellectual property requires proactive measures. Register your IP with the appropriate government offices to strengthen your legal position. Use clear notices like copyright and trademark symbols on your materials. Implement non-disclosure agreements and contracts to protect trade secrets and confidential information. Monitor for potential infringement using available tools. Maintain detailed records documenting the creation, use, and registration of your intellectual property. And conduct regular audits of your IP portfolio to ensure protections remain current and enforceable. The consequences of infringing on someone else's intellectual property can be severe. Courts may award monetary damages, including statutory damages or compensation for lost profits. Injunctions can force you to stop using the protected intellectual property immediately. Infringing materials may need to be recalled or destroyed. Your brand's reputation and consumer trust can suffer significant harm. Business opportunities may be lost as pending litigation disrupts operations and deters potential partners or investors. In cases of intentional infringement, penalties can be enhanced to include triple damages and attorney's fees. If you receive an intellectual property claim, take immediate action. Never ignore the claim, as failing to respond could escalate the situation to litigation. Consult an intellectual property attorney who can evaluate the claim's validity and determine the best course of action. Assess the allegations by comparing your work or product to the claimed intellectual property. Preserve all evidence documenting how your alleged infringing material was developed. Consider negotiation or settlement if the claim has merit, as this may be more cost-effective than going to court. If necessary, prepare for litigation, especially if your rights are being wrongfully challenged. Understanding intellectual property law is essential in today's business environment. By recognizing what constitutes protected intellectual property, dispelling common misconceptions, implementing preventative measures, and knowing how to respond to claims, you can significantly reduce your legal exposure while effectively protecting your own valuable intellectual assets.